5 seconds to go. Start. Factually also, comma, the said writing was not a will because it was not attested by two attesting witnesses as is required to be done for execution of a valid will. Stop. It is also a fact that the said writing had not been registered and by virtue of the said writing either complete ownership or share of Rao Gujarat Singh was not transferred to Sumitra Devi, thus, the High Court in its impugned judgment rightly ignored the said writing executed by Rao Gujarat Singh. Stop. Para. While rejecting the submissions made on behalf of appellant regarding the mental capacity of the testator to execute a will, the apex court has observed in para 16 as under para bracket start the submissions made with regard to the mental capacity of Sumitra Devi at the time of execution of the will cannot also be looked into at this stage because the mental capacity of the testator to execute a will being a question of fact, we would like to accept the findings arrived at by the court below and all allegations with regard to soundness of mind of Sumitra Devi at the time of execution of the will or allegation with regard to undue influence of the present appellant with whom Sumitra Devi was residing at the time of her death cannot be looked into by this court as they are the issues pertaining to fact. Stop. We, therefore, do not accept the submissions made with regard to validity of the will executed by Sumitra Devi. Stop. Bracket close. Para. Prior to coming into force of the Hindu Succession Act, no co-partner could dispose of whole or any portion of his undivided co-partnership interest by will. Stop. But by virtue of section 30 of the Act, read with explanation, a co-partner derives his right to dispose of his undivided share in Mitakshara joint family property by will or any testamentary disposition that is by virtue of law. Stop. The said provisions reads thus, para. Testamentary succession, any Hindu may dispose of by will or other testamentary disposition any property, which is capable of being so disposed of by him or by her, in accordance with the provisions of the Indian Succession Act, 1925 within bracket 39 of 1925, or any other law for the time being in force and applicable to Hindus. Stop. The interest of a male Hindu in a Mitakshara co-partnership property or the interest of a member in the property shall notwithstanding anything contained in this act or in any other law for the time being in force, be deemed to be property capable of being disposed of by him or by her within the meaning of this section. Stop. Para. In a case of the apex court has dealt with section 30 on the Hindu Succession Act and especially in para 7 has observed as under para section 30 of the act, the extract of which has been referred to above, permits the disposition by way of will of a male Hindu in a Mitakshara co-partnership property. Stop.